Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
What should have been a mundane afternoon on August 24, 2006, turned into a dreadful experience for Andrew Wijangco when two armed men held him at gunpoint in a parking lot in Parañaque City and drove off with the car he was driving, his father's 2003 Jaguar X-Type. Andrew reported the carnapping incident to the police and to the insurer of the vehicle, UCPB General Insurance. He submitted to them the required documents to process his claim under their vehicle insurance policy. Andrew's father, Wilfredo, the registered owner of the stolen vehicle, made a formal demand on UCPB General Insurance after the latter failed to act on the insurance claim despite repeated follow-ups. UCPB General Insurance later informed the family that the vehicle had been recovered by the traffic management group. It also informed Wilfredo that it would place his claim on hold and eventually close its file on the matter unless an investigation clearance from the traffic management group was submitted within 60 days. When Wilfredo received no response from the traffic management group, he filed a complaint against UCPB General Insurance for violation of the insurance code and for damages. UCPB General Insurance denied liability, alleging, among others, that Wilfredo had no cause of action because the vehicle reported as carnapped had already been recovered by the police. The regional trial court granted the insurance claim, giving credence to Wilfredo's testimony. After the Court of Appeals reversed this ruling, the case reached the Supreme Court, which ultimately reinstated the trial court's decision. How does the law protect insured parties when insurers delay or deny payment? Does the recovery of a stolen vehicle prevent the insured owner from receiving full payment under an insurance policy? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 19th of December 2025. In today's podcast episode, we will discuss the subject matter of insurance within the context of Wilfrido C. Wijangco versus UCPB General Insurance Corporation Incorporated, GR number 257086. This case was penned by Associate Justice Henri Jean Paul B. Inting and decided by the Supreme Court 3rd Division on April 23, 2025. And back with us today to discuss this case is Attorney Jose Maria G. Hofileña, member of the Commercial Law Department of the Philippine Judicial Academy. He is also the Dean of the Ateneo de Manila University School of Law. Hi, Dean Joey. Welcome back to the Supreme Court Podcast. Thank you for joining us once again.
Hi, Mike, and thanks for the invitation again, and it's nice to be back.
Right. Dean, so in this case, there was a carnapping incident, but what exactly led to the controversy surrounding the claim for insurance by Wilfrido Wijangco?
Well, this case, as you did point out, is an insurance case. No? And then I always tell my students that most of the insurance law cases that make its way to the Supreme Court involve the insured making a claim against an insurer, and which the insurer believes it is not legally obligated to pay. You know? So in that sense, this case is not any different. This particular case began when a certain Andrew Wijangco reported on the same day of an incident, first to his friend, thereafter to the police, the occurrence of an alleged theft of the motor vehicle that he was driving, which was a Jaguar. This vehicle was registered in the name of his father, Wilfrido Wijangco, who had it insured with UCPB General Insurance Company. About a week after this incident occurred, Wilfredo, as the insured, filed an insurance claim based on the theft clause of the insurance policy, under which the insurer agreed to indemnify, the insured, or Wilfredo in this case, for any loss or damage to the insured vehicles occasioned by theft. But despite the insurance claim and the subsequent submission of supporting documentation, UCPB General denied the insurance claim.
Mm-hmm. Dean, what were the reasons cited by UCPB General Insurance in refusing to approve the insurance claim despite the submission of documentary requirements? I note that there was even a requirement to secure a clearance from the traffic management group and a certificate of non-recovery. Were this part of the original list of requirements that was asked of Wijangco?
Well, UCPB raised, several reasons for denying the insurance claim. And if I organize them in this fashion, This would be the first is one. The first is that it could not be liable according to UCPB for the loss of the vehicle because the vehicle was in fact not lost. It was in the possession of the traffic management group after the police successfully recovered the same. You see, in insurance law, the liability of an insurer rests upon loss or damage to the insured property. Since the property is not lost, I suppose their view is there can be no liability. The second argument really that they relied upon was one that alleged that the theft did not occur. So, again, they relied on testimony of certain persons who had given their testimonies that there didn't seem to be a situation where carnapping had occurred. No? See, in insurance law, even when loss or damage to insured property is not an issue, an insurer may be held liable under an insurance policy only if the loss or damage to insured property is caused by a peril contractually agreed upon. And in this case, that peril was theft. So basically, the insurer asserted that in light of these testimonies, Wilfredo was not able to adequately establish that theft had occurred, and therefore, the insurer cannot be held liable. And finally, UCPB relied on the provision of the insurance code that conditions any liability on the part of the insurer to the timely submission by the insured of a valid notice of insurance claim. In this connection, UCPB asserted that there were defects in the claim insofar as compliance with contractual requirements that were necessary to constitute a valid insurance claim under the policy. So, for instance, they cite that the alleged theft was not timely notified to the police, that the insured did not sufficiently cooperate in the investigations to the incident, and as you mentioned, there was a failure on the part of Wilfredo to submit certain required documents, like that clearance from the traffic management group and a certificate of no recovery. So, the property was not lost, or the peril did not occur, or the procedures for the claim were not fulfilled. So these were the essential arguments put forward by UCPB in denying the claim.
Which prompted Wilfredo to file that case against UCPB Insurance before the regional trial court. And he cited some legal basis for this, Dean.
Yes, that's right. Wilfredo anchored his, the validity of his claim on his position that, first, even if the Jaguar was recovered and in the possession of the traffic management group, the liability of the insurer was already triggered the moment the vehicle was taken from his son at gunpoint. So in other words, the loss agreed to be covered under the insurance policy had already occurred, and the recovery of the vehicle does not negate that fact. Secondly, he had sufficient proof that the peril agreed upon, that is, theft, had indeed taken place. And lastly, that his claim was timely made and that he had complied with the contractual conditions in connection with an insurance claim under the policy, such as timely notifying the police, cooperating with the investigation, also timely submitting his insurance claim around a week after the incident. As for the alleged failure to submit a TMG clearance, Wilfredo's position was that that specific document was not included in the list of documents agreed upon with the insurer to support an insurance claim. Thus, he cannot be made to suffer the failure to submit that document because it was not required.
And what is interesting here, Dean, is that we have two different rulings here. So the RTC ruled in favor of Wilfredo, but the CA reversed this ruling. So can you walk us through the differences in terms of the reasoning of the RTC and the Court of Appeals?
Yeah. Well, I mean, to put it very simplistically, the RTC essentially agreed with the arguments raised by Wilfredo, i.e., the fact that the vehicle was in the possession of the TMG and not lost was immaterial because the loss that was agreed to be indemnified by insurer already occurred. He was able to sufficiently prove carnapping, and that the documents that were required, which the insurer was citing as a reason not to pay the claim, were actually not required in the policy. On the other hand, the Court of Appeals gave credence to I suppose the testimonies provided by UCPB. They said that it's not sufficiently established that the carnapping had occurred, which is to say that the peril did not exist so as to make them liable. So it was really a case of RTC supporting the views expressed by Wilfredo and the CA siding with the views presented by UCPB.
And ultimately, it's the Supreme Court who settled that conflict, that dispute. And it ruled in favor of Wilfredo.
It did. No? So obviously, the Supreme Court found the arguments of Wilfredo and the evidence of the record as supporting the complaint. So, that the agreed peril theft did occur and caused the loss of the vehicle, and that the subsequent recovery of the vehicle was immaterial. And secondly, also that the defect in the conditions for timely notification to the police and cooperation in the investigation, submission of required documents, these were all compliant. No? Wilfredo was all compliant with the policy and the law. If I can just add, Mike, on these particular points, I think it's very interesting that the Supreme Court relied on Section 249 of the Insurance Code as providing guidance on how those particular issues were to be resolved. The Insurance Code in general prohibits insurance companies from engaging in so-called unfair claim settlement practices. These include ignoring insurance claims or not making timely payment of insurance obligations. In this connection, Section 249 of the Insurance Code provides a period within which insurance claims on property insurance are to be paid. That period of time is conditioned on the insurer's receipt of proof of loss and ascertainment of the extent of the loss or damage, but also has rules on when payment should be made if the extent of the loss or damage is not ascertained within a given period. So essentially, Section 249 provides at a maximum that the insurer should indemnify the insured within a period of 90 days from receipt of proof of loss of the insured. Now, interestingly, the court used this reference to 90 days, for payment as a basis to rule against UCPB's general argument about the claim of Wilfredo being defective. Because you see, under insurance code, unless a specific period is provided for by law, an insured who suffers a loss is required to file a notice or a claim with the insurer without unreasonable delay. And if the proof of loss is contractually required to accompany such notice or claim, the quality of that proof need only be the best that is available at that time. So if an insurer has issues with the timeliness of the claim and the sufficiency of the evidence submitted, the insurer must raise its objections without unreasonable delay, as otherwise the defects will be deemed waived. So what constitutes an unreasonable delay for this purpose is not specified by the insurance code. But the court looked at the 90-day period within which to make a payment of the insurance claim as a legislative indication as to what might be considered reasonable for other purposes in the code, such as objecting to defects in a notice or claim. So the court here noted the insurer objected to the timeliness and content of Wilfredo's notice and claim way beyond the 90 days. So, since it's beyond 90 days, it should already be considered in delay and would not be able to raise those objectives on the defects. No? And so the court also made reference to the 90-day period in 249 to support the order that required UCPB to, in fact, pay Wilfredo's claim, which is the situation contemplated by 249. According to the court, since under 249, UCPB was required to pay Wilfredo within 90 days from the submission of proof of loss, then given that it was already way beyond that, UCPB should pay and cannot compel Wilfredo to just take his car back in lieu of payment of the proceeds under the policy.
Right. And so, Dean, it's clear here that the time element is really important, right? For the insured to make the claim, but also for the insurer to inform the insured of any possible defects in the claim.
That is correct, yes.
And to also timely pay.
Yes.
Right?
Yes, that is correct.
And this is also a question of proving your loss, right? But the Supreme Court did say that Wijancos were able to prove evidence to support the claim of loss. But what about UCPB Insurance? What pieces of evidence did it present to cast doubt that there was a carnapping incident? In fact, they claimed that there was none. And so why did the Supreme Court rule that these were inadmissible?
Yeah, this case, although, touches upon insurance law, but there are, evidence, rules of evidence that the court, included, of course, is as rational for its decision. So UCPB did attempt to establish that there was no theft, and it based it on statements obtained from a security guard, I believe, who was at the scene, who claimed wala naman daw commotion from any theft.
Right.
So, it also presented an investigation report from the police, also saying that no carnapping, took place. But with respect to these testimonies, the court did not give them credence because A, the security guard was not presented to corroborate the statement, and B, the police officer presented to testify on the investigation report was not the same one who prepared it. And also, relating to the rules of evidence, UCPB General objected to the testimony of Andrew's friend. Remember, he reported it first to his friend, no? As being hearsay, since the friend did not personally witness the carnapping. So on this, the court reminded the parties that such testimony was actually an exception to the rule on the hearsay, since it constituted part of the res gestae. That's because, Andrew's friend's testimony should have probative value because the narration of Andrew to him was spontaneously made immediately after the commission of the alleged crime. No opportunity to conjure up the false statement. And if I just, maybe as a last point on evidence, just also take this opportunity to mention that the court did remind the parties about certain burden of proof rules applicable to insurance claims. And that's that initially, an insured has the burden to prove that a loss had occurred from the agreed peril. And after that is done, the onus shifts to the insurer to prove any exception on which it might rely to deny a claim.
Right, and those are really helpful. It's interesting that you pointed out, even if this is an insurance case, you still have to deal with the rules of evidence, just as in any other case, Dean, right? And perhaps really the meat of this case, we try to answer this question, Dean. Does the recovery of a carnapped or stolen vehicle prevent the insured owner from receiving full payment under an insurance policy?
Yeah. Well, on that particular one, the court had given the view that in this particular case, it does not. No? Again, first of all, they did anchor their position on the fact that what the insurer agreed to in the policy was to indemnify the insured in the event there is a loss or damage on account of the peril insured, which includes theft. Okay. Theft had occurred. The car was lost. And according to the court, at that moment in time, the condition for the indemnification already occurred. And the fact that the car was recovered later on does not negate that fact. The second thing is that, again, as I mentioned earlier on, there is a 90-day period in the code within which the insurer should pay a claim on property insurance. No? And in this particular case, that 90-day period had already expired. And in which case the court had said that, you were obliged to pay it already. So since the 90-day period has passed, then you can no longer compel, the return of the vehicle in lieu of the payment of the insurance proceeds. So the right to the insurance proceeds are already attached, and that is the relief that can be granted to the insured.
And then I'm just curious, and maybe asking for your personal opinion on this. Wouldn't this be unfair, though, on the part of the insurer if, say, had they been able to find out that the car was returned earlier within the 90-day period, would the case have been different, perhaps? Or liability had already set in the moment that the car was lost?
Yeah, I think if the car was recovered within the 90-day period and there was in fact an attempt to return the car in lieu of payment of the insurance proceeds, it might have been different, I think. There is still a liability in some sense, I suppose, but payment of the proceeds may not be the only act of rectifying this situation. And I say this only because the Supreme Court did make that statement that after 90 days have passed, the insurer can no longer compel the return of the car to the insured in lieu of payment of the proceeds. No? So that statement alone gives an indication that if it were within the 90 days, maybe it's still possible. No? Maybe it's still possible. So that's the interesting part of the situation. But if you'll allow me to offer a certain view here as well. No? In the Civil Code, there is Article 2207 of the Civil Code, which provides for subrogation rights on the part of an insurer who pays an insured, in property insurance. And that provision essentially says that if an insurer pays an insured, then on property insurance, then if the loss or damage was a result of a wrongdoer, a wrongdoer's act or breach of contract, then the insurer is subrogated to the rights of the insured and can proceed against the wrongdoer to recover what it had paid.
Right.
Now, in a case of carnapping, again, you lose possession of it, and that's a crime, right? And part of the penalties in an act of theft is restitution of the property.
Right.
Now the question is, to whom does it go? Okay? Will it go back to the insured, or can the insurer make some claim on it? I paid the insured, that should be mine.
Yes.
Okay. Now on that one, I think what will help in analyzing it is the whole concept of insurance. That insurance is a contract of indemnity. It is not something for which generally you make money out of. No? Because if the car is returned to Wilfredo and he gets to keep the insurance proceeds, in effect, he enriched himself with the proceeds. No? And that's not the function of insurance. The insurance is really indemnification, putting you back to the state where you were prior to the loss. And therefore, in that particular case, I would like to offer the possibility of an argument that since the insured had already received the proceeds and is not willing to return the proceeds, then the claim to the car should belong to the insurer. Again, I say that knowing that the sanction of restitution probably requires a court order of some sort. No? So there'll have to be some proceedings perhaps to do that. No? But I think in line with those principles, the insurer has a claim, probably has a supportable claim to the vehicle after it pays the proceeds.
Right. Perhaps we'll just wait for the proper case for that issue to be resolved. But finally, Dean, what should our listeners keep in mind after this discussion on insurance and making some insurance claims?
Yeah. Well, again, I suppose lessons for insurers, of course, is clear. No? I mean, you need to be diligent in responding to a claim. I note that in this particular case, although the notice of claim was timely made, parang a week after the incident occurred, it took the insurer a number of months, around 5, I think, to first respond. And this in itself, I believe, already puts the insurer in a disadvantaged position. No? So be diligent. No? There are these provisions on unfair claim settlement. Take them to heart as insurers, and each client, big or small, are important to you. And therefore treat them all with the dispatch that the situation requires. Now, for the insured persons, I think, of course, there's benefit that can be seen in this case from being proactive in asserting your claim against your insurer, both in terms of the timeliness of things that you have to do, as well as the quality of your proof of loss. No? So again, a loss is always a moment for sadness and devastation, especially things like this, like theft. But be proactive, in making your claim. And for all of us, I think the case affirms that the existing rules and doctrines in insurance law, has it in this case. This case reaffirms those principles, but it introduces also what seem to be new insights. Such as what might constitute a heretofore undefined, unreasonable delay in respect of objecting to defects in claims, which is essentially 90 days. And also, the court here said that they need to prove prejudice as an essential element to arguing based on a breach of policy provision. So there are things to be learned in this case, which are, I think, insightful in that they seem to be new, apart from affirming the settled doctrines.
You always learn something new every time we do the podcast. So thank you very much, Dean Joey Hofileña, for joining us again. And I should note, Dean Joey, that this is our last episode for 2025. So thank you very much for being part of the Supreme Court Philippines podcast for 2025.
Well, happy holidays to you and to everyone.
Right. Happy holidays. And we will be back in January for our 100th episode. In the meantime, if you wish to read the full text of the court's decision, please visit the Supreme Court website and e-library and search for Wilfrido C. Wijangco versus UCPB General Insurance Corporation Incorporated, GR number 257086. Here's Steph Ateneo Beltran, Supreme Court Information Officer, for this week's updates.
From the Supreme Court of the Philippines, Here's the latest. The Supreme Court has held that while financial details of bank deposits remain confidential, the Cybercrime Prevention Act allows disclosure of bank account holder information for cybercrime investigations. In a decision written by Associate Justice Ramon Paul Hernando, the SC's First Division denied the petition filed by East West Rural Bank questioning the warrant to disclose computer data, or WDCD, issued by the court and the subsequent disclosure order issued by the Philippine National Police Anti-Cybercrime Group, which required East West to disclose bank account holder information of an account involved in a scam. The SC upheld the validity of the WDCD and disclosure order and clarified that while the bank secrecy law protects the confidentiality of bank deposits and their financial details, it does not prevent the disclosure of basic identifying information when allowed by law. Under the Cybercrime Prevention Act, law enforcement agencies may, with a court-issued warrant, require the disclosure of computer data necessary to investigate cybercrime offenses. In another case, the SC has ruled that the Commission on Elections, or COMELEC's unreasonable delay in investigating an election offense violated a mayoral candidate's right to the speedy disposition of his case. In a ponencia by Associate Justice Ricardo Rosario, the Court en banc nullified the COMELEC's resolution finding probable cause to charge Lobok Bohol mayoral candidate Petronilo Solomon Sarigumba for violating the Omnibus Election Code. The SC disagreed with the COMELEC, citing Article 3, Section 16 of the Constitution. The SC stressed that all persons are guaranteed the right to the speedy disposition of cases before judicial, quasi-judicial, and administrative bodies. When this right is violated, the SC will not hesitate to dismiss the case. The SC explained that under the COMELEC Rules of Procedure, a preliminary investigation should be completed within 20 days after receiving the respondent's counter-affidavit or after the deadline to file one has passed, and a resolution should be made within 5 days following that. Reiterating the need for justice to be fair, impartial, efficient, accessible, transparent, and responsive to the needs of the public, Chief Justice Alexander Mundo on Tuesday led the signing of the Record of Discussions with the Korea International Cooperation Agency, or KOICA, at the SC en banc Session Hall. The signing formalizes the framework for the scope, guiding principles, and operation arrangements for a $14.5 million grant by the Republic of Korea to the Philippine judiciary, which aims to modernize Philippine courts. Serving as signatories were Clerk of Court en banc Attorney Marifel Amibo Cuevas on behalf of the court and KOICA Country Director Mr. Jung Yong-sun. In his message of support, Ambassador of the Republic of Korea to the Philippines, Sang Hwa Lee, said that they hope to contribute meaningfully to the objectives of the Strategic Plan for Judicial Innovations 2022 to 2027 by sharing the relevant experiences and technical tools in judicial reforms and digitalizing systems. Senior Associate Justice Marvic Leonen, co-chair of the SC Committee on Computerization and Library, will oversee the implementation of the project. On Thursday, Honorable Maria Belen Ringpis Liban took her oath as presiding justice of the Court of Tax Appeals, or CTA, before Chief Justice Alexander Mundo at the en banc Session Hall, making history as the first woman to head the CTA. In attendance were SC Associate Justice Ami Lazaro Javier, CTA Associate Justices Catherine Manahan and Corazon Ferrer Flores, PJ Liban's family members, and CTA personnel. Prior to her appointment as CTA presiding justice, Justice Liban served as a CTA Associate Justice for 12 years. She was a regional trial court judge for 17 years. On Tuesday, the Office of the 2026 Bar Examinations Chairperson, Associate Justice Samuel Garlan, released the Frequently Asked Questions, or FAQs, on the application process and documentary requirements for the 2026 bar exams. Visit the 2026 Bar microsite or scan the QR code to read the full text of the FAQs. The Unified Legal Aid Service, or ULAS Interim Board, led by Associate Justice Alfreda Benjamin Kagiwa, has extended the relevant deadlines for the early compliance incentive under Section 1 Rule 11 of the ULAS Rules Manual. A covered lawyer or a registered organization that completes 40% of the applicable minimum hours on or before April 30, 2026 may still elect to give a financial contribution corresponding to the remaining 60% of the minimum hours, provided that the financial contribution is remitted on or before May 30, 2026, and that the election is indicated in a compliance report submitted on or before May 30, 2026. Complete information may be found at the ULAS Advisory Number 3. You are now up to date with the Philippine Supreme Court. I am Tiffany Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast as well as previous episodes on the Supreme Court Public Information Office's accounts on Facebook, YouTube, Spotify, and Apple Podcast. This podcast episode was produced by the Supreme Court Public Information Office, with Attorney Mike Navallo as overall in charge of production, Attorney Karen Martinez as supervising producer, Jay Rempilio, executive producer, Tiff Atendido Beltran, producer, May Sibal, Attorney Ian Aldueso, Attorney Sheila Reyes, and Ramir Simbahon as researchers and writers, Brian Austria, Don Ryan Balza, and Vini Laranio as audio editors, Lawrence Olanyo and Austin Aliscad as video editors, Bea Batong as graphic artist, and Tyke Flores and Jerome Batumalaki as web editors.